Hi, everyone. Welcome to Simply Multifamily. My name is Kiran Dhillon. I am a broker associate with Keller Williams Commercial, specializing in multifamily sales. Today, we have the privilege of sitting down with attorney Anthony Marinaccio of Marinaccio Law regarding new 2026 laws that affect owners of California multifamily properties. Welcome back, Anthony. Thanks for being here today.
Hi, Karen. Thanks for letting me on.
Yeah. So I wanted to start with AB 628, which is the new statewide law requiring owners to provide stoves and to provide and maintain working stoves and refrigerators in the units starting January of this year, 2026. Can you tell me what types of units or properties this new law applies to, and are there any exceptions?
Generally, it will apply to all rental properties except for single room occupancies or rooms where there are no kitchens. But basically, for the vast majority of landlords, it applies to everybody, to all rental properties, single families, all the way up to apartment buildings, duplexes, basically all rental units that have a kitchen.
And do owners have to provide the stoves and refrigerators to tenants who are already leasing the units, or does this only come into play when a new lease is entered into?
No, they do not have to provide it for tenancies that began in 2025 and before. However, if somebody requests that the refrigerator or stove be placed, at that point it would have to be because it is considered a habitability issue. So it's going to be on the same level as, for example, not providing heat or not providing running water or something along those lines. So it's important that, yes, if a tenant's having an issue with a stove or refrigerator, that a new one be provided, even if it was the tenant's prior.
Got it. And then how long do owners have to replace an inoperable refrigerator or stove once they're notified by the tenant?
Uh, it actually would be 30 days for any warranty issues. So, for example, if there's a recall, for example, you buy a Maytag appliance and the Maytag has a recall, you would have 30 days to make that fix. But for everything else, it would be reasonable, kind of similar to everything else in habitability. So, for example, if there's a lack of hot water, what would be reasonable to make a repair? If they call on a Saturday night, it's not fully unreasonable to have something repaired early in the part of the week after. But if it's something that can be done that day, then it should be done.
Got it. Let's say you are entering into a new lease. Does the tenant have the option to opt out and bring their own refrigerator? And then, if so, what's the best way for the owner to document that to make sure they're
So,
protected?
and it's really common, especially in Southern California, tenants will sometimes have their own refrigerator already and they want to use it. Um, a landlord has to provide just a notice saying that the law does require a landlord to provide the refrigerator, and that you're basically exempting yourself and you're going to provide your own refrigerator. However, and that would have to be initialed by the tenant, and the language is provided in the code. However, the tenant later on can make a decision saying, I would rather have the owner provide the refrigerator, and the owner would have to provide the refrigerator.
And you mentioned earlier about this being related to habitability. So do you see um, the lack of providing a working stove or refrigerator coming up as a defense in, say, like unlawful detainer actions?
Technically, yes, it could become a defense and it can become an issue. For example, if a tenant contacts the landlord saying that the refrigerator is broken and it's not, cooling food, or the freezer's not working, hypothetically, I haven't seen it yet, but it could hypothetically they could file a complaint. A tenant could file a complaint with the housing department or the county health department and have an inspection done to have it fixed. Or it could also become a defense to an unlawful detainer. Yes.
Okay, so it's important for landlords to be on top of this.
Correct. And I mean, stoves generally, I don't see too many issues over the years with stoves, but I know with refrigerators, they can become more of an issue because of the cooling and the freezing.
Got it. The second big change that we have comes in with AB 414 and the new rules surrounding security deposits. Can you tell us a bit
Yes.
about that?
So now the law kind of sped up, allowing for electronic payments and also service by email, specifically for security deposit itemization. So, for example, if a tenant vacates and provides an email address and everyone agrees that you can just send it to the email address, then a landlord can send the itemization by email, and also, if the parties agree, can return the money by Zelle or other electronic payment. The one of the big issues that have come over the years, for example, is and this clarifies that in the security deposit rules, is that if you have multiple tenants, how do you write the check? And it actually clarifies saying that checks should be written to all the individuals unless they've all agreed to just give it to one person or however, or split the checks. But otherwise, you write one check to everybody, to all the named tenants. So that was one change. Also by email, because of prior and the law still says this, where you would have to provide this itemization to the last known address. So if a tenant does not provide you a forwarding address, the law actually says that you return it back to the vacant unit, and it's assumed that that person should have done like a mail forwarding or something.
Okay.
But I've seen that over the years where no one gets it. So it's important that now with email, I think it will go a little smoother. That the 21-day period is still the same, but
Okay.
now you can just send the itemization via email as opposed to by letter.
Okay. That's good. Should be more efficient.
Yeah, it should be. No, I think it would be. And I know people already were asking for that. I know a lot of people would rather have email than a paper check.
Yeah, absolutely. And then the last one we're going to go over today is regarding a landlord's duties if there's a natural disaster. This is covered by SB 610. So what's changed here?
So there was a lot of confusion after, particularly the Altadena fires and also the Palisade fires, that who is responsible for the cleaning and the maintenance of a unit when after a natural disaster. So I know in Altadena, I also in the Palisades and there's around there, you had units that were heavily affected by smoke damage, and who is responsible to make those repairs. In addition, there were issues where, for example, the landlord would make the maintenance of the ducts, for example. But if a tenant did not fix the or didn't clean her sofa, for example, that could become an issue because then it would recontaminate the smoke. The smoke damage would recontaminate. So this law clarifies that a landlord is responsible for the damage for cleaning, especially, and for removal of toxic materials. So this might mean that they're going to be responsible for the entire unit, including the furniture, for the cleanup essentially aspect of it. It does provide a little guidance as to what would occur if the unit is destroyed in a natural disaster. There's a lot of difference on this. If it is completely destroyed, there's no responsibility to rebuild. So if it's burned to the ground, there's no responsibility to build a new unit. But if it's damaged where it's going to be remodeled and repaired, the law now clarifies that the tenant is allowed to move back to the unit at the same rent they were paying prior to the unit being or partially destroyed during the disaster. And this would only apply to natural disasters. They also added a little provision saying if there's which is pretty limited, if there's an evacuation order, for example. So, and this did happen, particularly in the Altadena area where there were a lot of tenants, but also the Palisades.
Right.
Where if you were you required to be out of your unit for so long due to a mandatory evacuation, that you are not responsible to pay rent for that time period while you were evacuated.
Okay.
So it's
So you're not
very limited.
responsible to pay rent for that period.
Correct. A tenant would not be responsible to pay rent for that period of the evacuation. So, for example, I know in the Altadena fires, there were some mandatory evacuations for a few days, some were a little longer. So that would be the time period, not at the not it's really not discretionary, just whatever the law says when the evacuation occurred.
Got it. And then if the unit becomes uninhabitable for a certain amount of time and the tenant's still on a lease, what then?
So the tenant would have the discretion if they would want to terminate the lease and just move on, they can. But at the end of the day, if the unit's going to be remodeled, a tenant is not responsible to pay rent, but they would be responsible to move back in once the unit is remodeled, but it would repaired. and it would have to be at the rate that they were paying beforehand.
Got it.
But it should be noted that there are lots of separate provisions for local laws. So,
Mhm.
for example, City of Los Angeles, City of Glendale, City of Pasadena, they all have their very, very specific regulations about remodeling and disasters. So you might want to look at that as well.
Right. So in summary, based on these three new changes we've talked about, what steps should multifamily owners take to prepare for these new laws?
I actually think for the security deposit issues, that may be would be included as part of the lease, the saying that you would accept the security deposit itemization as, and I actually think at this point, part of the lease should include, people's contact email address in addition to a phone number. I think phone numbers tend to change, but people don't tend to change their email addresses.
Mhm.
So that's helpful. I also think for the stove and refrigerator, I know um, for a lot of landlords, particularly in Southern California, I know that's going to be a big issue where they were not used to providing that before. Although recently they have been providing them more often. Um, I think that's something that I personally believe that they probably should be providing that. Well, the law now does require that we would
Right.
have to provide them, and I think that's important. It's also important that if you are buying new appliances as a landlord, that you keep up with the warranties and with the any recall notices, because it's very specific about the recall notices, particularly for appliances.
Mhm.
So, for example, it would be considered uninhabitable if the recall notice is never addressed, for example, or something along those lines. And then, unlike before, um, if a tenant does make a request to make a repair to a stove or refrigerator, that needs to be done. It's basically it's like I said earlier, it's on the same level as lacking hot water or lacking heat. So it's important. And for the disaster, the issues relating to disasters, I think that's a very limited issue. And I know it was really in response to the wildfires,
Mhm.
but it can be applied to just general fires. It can also be applied to earthquakes if there's one, or other types of natural disasters. I think it's important to keep up on that if it does happen, and depending on what happens to the unit. The wildfires created a special issue, particularly with smoke damage, particularly in parts of the San Gabriel Valley. So that's why I think that's why the law was created.
Yeah, that makes sense. Well, thank you, Anthony, so much for being here today. The laws that we talked about are kind of broader California based. So just like you mentioned, if you happen to own property, anywhere in Southern California or Northern California, be sure you're familiar with the local laws, because like you mentioned, many of these cities have much more specific rules that you have to
Right.
follow. So if anybody has questions about that, they could reach out to your office.
Yes, you can always call my office. The number is 818-839-5220.
Perfect. Thank you.
Thank you.